Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay. Now let's head to Milwaukee, home of happy days, so to speak, and some beer. So Milwaukee has been successful. They've successfully defended suit brought by a terminated firefighter. I find this very interesting. So the firefighter was dismissed. She was terminated in 2020, January of 2020, for something that allegedly happened in 17.
Well, this is complicated now. It's a he, and he's a acting lieutenant. So he must have been on the list or whatever. He's an acting lieutenant, and he gave her low grades and
a probationary subordinate. I mean, yeah, let's get into that. So, as he's acting lieutenant, he's accused of subjecting a probationary subordinate, right, to a hostile work environment. He had previously given her a couple low grades, but then it gets kind of interesting from there. So the subordinate female accused the lieutenant of sexually assaulting her. This kind of comes out of nowhere. And that results in him getting arrested, incarcerated, and not surprisingly, placed on suicide watch. When people are, let's say, potentially wrongly accused, comes out of blue, maybe, and so now he's suicidal.
There's a question about whether or not he belonged on suicide watch, or they put him on suicide watch just so that he wouldn't be able to get out on bail. That was I was reading through it. I'm saying, boy, I wonder. And apparently the victim had some family members that were involved in.
Well, that's what we want to get to, right? So as they investigate this, so stop here. So now he's indicted. There's a criminal proceeding at the same time pending. And you and I talked about similar issues like this before. So I'll get to that in a minute. So there's a criminal issue now happening because she raised, oh, wait a minute, he had sexually assaulted me, right? The police apparently found it credible enough to incarcerate him. So the civil matter, the discipline against him, is now put on hold. And sometimes that's a process that happens where the DA says, listen, we do not want you to interfere with anything. So the department agrees, we will put our investigation on hold, the civil investigation. Sometimes you think because if he's convicted, we don't need to investigate anything. We'll terminate him retroactively, right? But so they put everything on hold. That's kind of the key interesting part of this case. So then it comes out where this gets really interesting. Well, I presume you picked this case for discussion. Then it turns out that the investigation reveals that the female victim had a relative in the police department. She had a history of making threats like, oh, I'm going to make one call to my family and you're going to get in trouble. But that wasn't all. They could not in any way corroborate the sexual assault. Now, I don't have details, at least in front of me, on the sexual assault, whether she claimed there would have been other people or it was in a public place or who knows. Because a lot of times he said, she said.
And that's the classic. And what, as an investigator, what you're looking for is any sort of corroboration. If you have, because they're both bruising, right? If anything, could be video, could be someone says that they're at a certain location and now we have cell data to put them at the location, or other witnesses who can say, yes, they were at that location, or immediately afterwards, the person did report this,
right?
Or told me.
Or take the opposite. You said it happened at 2:00, but at 2:30, you're out hanging at a bar, right? I mean, I don't know what the facts are, but so those two things, her common threat and the fact that they couldn't corroborate in any way, it gets dropped. So now the disciplinary investigation is free to continue, right? Just because there's no evidence of a crime doesn't mean that he wasn't, retaliating or took the first action against her, right? Ending in the bad.
He did. And then, he was engaging in some sort of hostile behavior toward her.
Right. So, and he was making some sexist comments. He said, you have in there racist comments too. I don't know if she's African-American or something, but
that wasn't clear, but yeah.
All right. In any event, so the the issue you pick up from is the Sixth Amendment issue, right to present witnesses, right? And so they tried to claim, I'll kind of summarize this if you want to expand it, but he tried to claim, listen, because of the criminal proceeding, we couldn't present witnesses. And the court says that's not true. You weren't denied the ability to present witnesses. You were told you couldn't interview them for a while, but ultimately you were able to present them as, right, in your case, you were not denied access to them. So there's no Sixth Amendment denial. And the court really says it was a temporary hold, basically. And interestingly, the court, doesn't criticize the DA or the employer for taking either tact. Don't talk to witnesses and okay, we're going to put everything on hold. I didn't take that as the court having an issue with that. But the court ultimately said, look, you did ultimately present the witnesses. So, it's a very short way of summarizing it, but
yeah, I've got so many questions on this one. And, certainly if there's anybody from Milwaukee listening that has some details, he was terminated for insubordination, basically for not doing what he was ordered to do. So my question would be, was that refusing to answer questions? When he was called in as part of the interview, did he refuse to answer questions? That could be, because he didn't sue alleging wrongful termination. That was one of the questions. He didn't sue. So it's possible he refused to answer questions, gets fired, goes to an attorney, and then the attorney says, you had to answer the questions. You can't, if you don't answer the question, you can't sue for wrongful termination. Oh, what are we going to sue for? Well, we can go after him on the Sixth Amendment.
Creative, but not availing.
And they allege essentially that on the criminal case, because the firefighters were told not to talk to anyone while the criminal investigation was going on, that prevented him from preparing a defense. And the court rejected that. And you can read the reasoning of the court. They did a pretty good job outlining what the Sixth Amendment requires, but it's really limited to presenting witnesses, not necessarily interviewing them in advance of the trial, at least according to the ruling.
Yeah, and so the takeaway really is this wasn't a bad approach, right? If there's truly an ongoing active criminal investigation, let that take place. Nobody wants the interference allegations. And kind of Garrity kind of sneaks in here a little bit too, right?
It absolutely does. And it's a little bit beyond what we can get into here, but Garrity is front and center here. But once the criminal charges are dispensed with, Garrity goes away, right. And either way, the employer, even if this lieutenant or acting lieutenant was facing criminal charges, if the employer orders him to answer questions properly, does it properly, triggering Garrity, the firefighter has to answer the questions, even though the answers, potentially are immunized. And then it's up to the police now to make sure that they don't use it, they don't rely upon it, they don't have access to it, and so on. So there's a bunch of different things, and there's ways that the record can be sealed and so on and so forth. But big point here is that even if you're facing criminal charges and work-related criminal charges, because Garrity doesn't apply to things that didn't happen at work, that aren't connected to work, but where it's work-related, and this is work-related, a sexual assault that allegedly took place on duty, if you're ordered to answer questions, you have to answer the questions. And so now, and it sounds like the fire department was told by the prosecutor, just hold off on that. And the other part of this is the prosecution is not going to want you interviewing the victim in a sexual assault case. So how can you do a disciplinary investigation if you can't interview the victim? So interesting.
And look, I was getting too far off, but the burden of proof on criminal justice, right, is beyond a reasonable doubt. Right. That's the highest possible burden. That's not your burden when you terminate someone or for disciplinary proceedings. You don't have to prove beyond a reasonable doubt. So they could have, if the department wanted, they could have then interviewed the female and said, okay, the police didn't believe you, but we might.
Right.
And could have.
It's not that the police and the prosecutors felt that they could not prove beyond a reasonable doubt. That's the standard. So they say, all right, we can't prove it beyond a reasonable doubt. If the case was based on the normal civil standard, fair preponderance, they might have had a case.
Yep.
And certainly the city at that point is able to move forward with it. But again, he wasn't terminated for that. He was terminated for refusing an order, which I'm assuming, my assumption is it was in order to answer questions, and he mistakenly didn't answer. So